Swayam Prabha. Digital India. Educated India.
So, moving on, friends, let's look at yet another very important topic area in the Constitution of India, which is very prominently important in terms of uh, public policy of the land and in the implementation of administration. Uh, I think the topic on fundamental rights is there in part 3 of the Constitution of India. Now, you would notice that the Constitution has certain parts which are integral to the discussion under this chapter. And those are fundamental rights, second, fundamental duties, and third, the directive principles of state policy. Now, I think each of these would require a lot of attention from all of us to understand and have deep insights on the public policy framework in terms of rights, which, of course, is not only important because when we talk about rights, it's important that we also speak about our duties. Now, no right can emanate without the performance of duties. And duties are paramount in democracy, in any given society. And duties are those kinds of obligations that an individual ought to perform in a given situation. So when we say that rights and duties are important, I think it goes back to the jurisprudence of what we call as the law of obligations. As citizens, as human beings, as individuals staying in a society, it is our duty to ensure peace and order and tranquility. It is our duty to protect others' interests and others' rights. And hence, you are having an obligation by just the call of justice, equity, just by the call of the state. And I think your duties will be paramount for the protection of your rights. Interestingly, rights can only be protected if you have done your duties effectively. Rather, there are principles in law which say that one who seeks equity or justice must do justice or equity himself. So you are only entitled to justice and equity if you have performed your part of the obligation towards justice and equity. So if you are wrong or if you have committed a wrong, then your claim to justice and equity may also be infringed to the extent of the wrong that you have committed. So duties are very, very important to the discussion on rights. And of course, the directive principle of state policy does lay down the kind of vision document for the states to look at what I would call as the welfare interest of the people in India. Now, please note the Constitution being the most fundamental document. It is this document that vastly speaks about many things. We have covered the Constitution's discussion on what is the territory of the Indian state. We also discussed citizenship. Now, please note, citizenship rights can also be considered as constitutional rights, which means, please note, if you are entitled to claim a citizenship and if that is denied by the state, it is in one sense infringement of your rights under the Constitution. Please note it down. And hence, what does the Constitution do as the fundamental law, as the governing law, as the foundational law, as the umbrella law, as the most important law that gives public administration the space, the objective for its performance, is that it talks about certain kinds of rights which are considered fundamental. Now, when we say certain kinds of rights are fundamental, they are something that are non-compromisable. They are something that are non-alienable. They are something that the Constitution holds as supreme. They are something that the Constitution wants to treat it as paramount in terms of protection of human rights. Of course, please note, what is mentioned in the Constitution is only a list of rights, but they are not necessarily the only set of rights that are there. Of course, in any legal system, you would not only have fundamental rights that are defined in the Constitution, you could have legal rights. And a legal right is something that is given by a statute of the Parliament or by an act of the state, and that could be simply different than what is so fundamental. So, fundamental rights are those that are mentioned in the Constitution. They are treated to be core, they are treated to be important, they are treated as the vision of the founders as those kinds of rights that citizens and persons should enjoy. When I use the word citizens and persons, the precise reason is to tell you that there are certain kinds of rights that only citizens are entitled to under the Constitution, and there are certain kinds of rights that even a non citizen is entitled to. For example, uh, uh, let's just take a couple of rights, okay, just for the discussion. Now, please note, certain of these fundamental rights that I'm going to state are available only to citizens and they're not available to foreigners. Okay, what are these? Those that are mentioned in Article 15, 16, 19, 29, and 30. So, if you take these 5 articles, you will notice that fundamental rights in these 5 articles are only for citizens, and foreigners are not entitled to any of these fundamental rights. Article 15. What does Article 15 speak? They speak about prohibition of discrimination on the grounds of religion, race, caste, sex, and place of birth. Article 16 talks about equality of opportunities in the matters of public employment. That is only for citizens. Article 19 has 6 freedoms: speech, expression, assembly, association, movement, residence, and profession. These are only for citizens. 29 is about protection of language, script, and culture of minorities. So only Indian minorities can exercise fundamental rights under Article 29. And finally, minority institutions can administer educational institutions under Article 30. That is, minority citizens who establish those educational institutions can seek the protection under Article 30. These are 5 such fundamental rights in Part 3 of the Constitution that only citizens have a right to. However, what is more interesting in terms of the dynamism of the Constitution of India is rest of the rights that are mentioned in the Constitution in Part 3 are available to foreigners as well. There are 11 such rights that a foreigner in the Indian Constitution can be entitled to. So the Constitution is an all-encompassing document. I think it protects human rights, and it does not necessarily look at protection of citizens' rights. Right. So, what can a foreigner claim in India as a part of his constitutional right of the Constitution of India? He can claim equality in terms of equality before law and equal protection of law. He can claim things like the freedom of consciousness in terms of religion, to practice, profess, and propagate religion under Article 25. He can claim Article 21A, which has been brought into the Constitution as a recent right, on the right to elementary education. And of course, most importantly, a foreigner can claim under Article 21, right to life. So, just to set that context between citizens and foreigners, I think Part 3 deals with both of them and equally tries to give the democratic principles of human rights to all persons, as the case may be, under the principles of the Constitution. Now, again, going to fundamental rights, one should understand that when we use the word fundamental, it means this is the public policy of the land which is core, which is something that the society claims as very valuable. That's why they're fundamental. They are the founding rights. Of course, when we got independence and when we became a democracy, I think these were the first set of rights that the Constitution gave to us. Of course, then we can talk about different other sets of rights that we got under the Constitution, but these were supposed to be the first sets of rights. And also, please note, these were the so-called rights that the Constituent Assembly and the generation of our founding fathers to the Constitution gave it to us. So they gave these rights to a generation that they believe would enjoy it and be entitled to the same And hence, I think these were rights that our fathers wanted us to enjoy. They wanted us to have, the privileges of this kind of rights. And I think when you look at fundamental rights, don't forget, friends, that the whole value of fundamental rights is something that is derived from the preamble. The preamble is the guiding light. The ideals, the aspirations in the preamble actually resonate in the way in which fundamental rights have been inscribed in the Constitution, and in the way the fundamental rights have been interpreted in the Constitution. For example, you will notice that some of these fundamental rights deal with socio-economic conditions. Isn't that interesting? Because you're talking of justice under the aspect of the preamble, which is social justice, it says economic justice, it says political justice. So when you deal with social justice, how does fundamental right deal with the concept of a social justice? Just to give an example, you will notice that we have legislations and we have constitutional protection against what we call as bonded labor, right? And this is a matter of social justice, that you cannot practice bonded labor. You cannot practice social inequality of what we call as the rule of untouchability, or the rule against the practice of untouchability. So social justice is also about gender equality, which is quite prominent in some of the societies still in India, or prevalent in India. So you will notice that fundamental rights actually resonate the ideals of the preamble. And to that extent, I think you will notice that you have fundamental rights that remove these social inequalities, and they give you certain kind of rights so that society does not practice those kind and forms of discrimination, as the case may be, right? So that is what is the introductory part to this course, or to this chapter. And I think from here on, let's try and understand why the rule on the constitution becomes core and important, and how do we look at the supremacy of the constitution in terms of protection of fundamental rights. Friends, one would believe and understand that for any kind of political democracy, and to equate and decide whether the political democracy is thriving, is protected, and democratic principles are the way of public administration. See, please note, democracy is not only a way in which you elect your government. Democracy is also the way in which public administration is implemented. Every aspect of democracy becomes critical, it becomes crucial. So the concept of fundamental rights, friends, one would say, as I've said in the past, originates right from the time of Magna Carta, and it is about those kinds of rights that you demand from the ruler or the state, and you don't think the ruler has the ability to undermine some of these rights. So I think the rule of law that Magna Carta wrote, which means, please note, Magna Carta insisted that, look, this is what the law is, this is how the rights would be administered. It is not based on what the king says or what the monarch says. So I think precisely laying down such a rule of law, which will be the rule of administration. Public administration is about the letter of law, the spirit of law. It is not about the whims and fancies of the ruler or the administrator, as the case may be. So I think fundamental rights does come from that kind of an origin. I think it is very important that one understands A.V. Dicey's writing on what he mentions as rule of law, where he actually says three very important things. He says that, look, when you talk about rule of law against rule of men, see, these are two interesting distinctions that you have: rule of law and rule of men. So, what do you expect democracies to follow? You expect them to follow rule of law. And rule of law clearly means that there should be supremacy of law. There must be equality before law. Because when you talk about rule of law, you don't discriminate between the color of the person to give your judgment. So you don't see who the person is. He may be rich or poor, he may be affluent or not. You just apply what the law asks you to do. So So equality before law is a very important principle of rule of law. However, you will notice that while you talk about equality as a principle of rule of law, equality before law, right? Before law, everyone is going to be treated equal, and equal protection of the law, which means law must protect everyone equally, irrespective of his income, wealth, status, contacts or whatever. That now has become a fundamental right in Article 14. So, so if you read Article 14 to 18, you will see the principles of equality as a fundamental right. However, equality before law is actually originated by the principle of rule of law, right? And the predominance of a legal spirit, like you apply legal mind, legal logic, you apply the sense of justice, you apply the sense of morality, you apply the sense of ethics. I think that is what the principles of rule of law actually mean. And to be honest, the predominance of legal spirit is so very core and important to how fundamental rights are being, are emerging in modern democracy. The reason why you talk about predominance of legal spirit is, please note, fundamental rights as they were given to the Constitution of India were never supposed to be static. They were never supposed to be static. They were supposed to be quite dynamic, in sense that suppose you say equality before law. Now that what has been written has to be practiced. Now, what do you mean equality before law may differ from time to time, from case to case, from generation to generation, and hence the experiences on equality before law has changed from 1960 to what we speak today in 2023. So the legal spirit very clearly says that law is generally not supposed to be, as it is. It's not stagnant. It's not something that is rigid. It has to be changing. A changing law is always a law that is flexible. A changing law actually adopts to the concept of justiciability. A changing law adopts to, being, say, objective in how the law looks like, but very subjective in terms of its application, as the case is. And fundamental rights, friends, are supposed to be read by the judges. They are supposed to be implemented and interpreted by the judges. So, what does equality actually mean? Now, there is no definition of that, and hence someone would have to read case laws of the Supreme Court and the High Court of what they meant in specific circumstances. And that very clearly brings in the legal spirit, and that also is the way in which rule of law is supposed to be administered vis-a-vis the fundamental rights. So, please note, fundamental rights are fundamental to every citizen. Now, when we say every citizen, you do not make a discrimination between just say a local community or a local person. It is actually sometimes very fundamental even to civil servants, to public administrators, even to judges. Sometimes you will notice that a judge may want to exercise the freedom of speech and expression, and it's not permitted for him to do so. So, even for those who are on the side of the government, fundamental rights becomes important, right? It is the country's political process or a political system. And while reading any country's constitution, if you just read the chapter on fundamental rights, you probably understand the political process of that country. You understand the public administration, as it were, in that country. So it gives you a kind of an insight of how public administration is actually chartered into. However, at this point of time, one should understand that when we speak about fundamental rights, please note that fundamental rights are not only about individuals. It is not only about what we call as natural persons. Some of these fundamental rights can also be, entitled or given to legal persons, or what we call as corporations or companies, or what we say as juristic personalities. So fundamental rights are available even to them, as the case may be. We'll talk about it a little later. So it's not that only natural persons enjoy fundamental right. Also, it is important at this point of time to say that rule of law also looks at the limitation of rights. So when we say rule of law, friends, when we say fundamental rights, please note these rights are not absolute rights, right? There is always a limitation to what these rights are. Every right is a qualified, limited right sometimes. Rather, I think every right comes with a duty, right? So you can understand those with the concept of saying that none of these are absolute rights, because rule of law always looks at limitation of rights, because that is very important, right? So your rights are not absolute. There ought to be reasonable restrictions. You have to exercise this right with a reasonable sense of responsibility, and there has to be a balancing of rights if necessary, because very time and again you will notice that there can be a conflict between two fundamental rights, and hence the balancing of rights may also be required. So if there is a conflict between, say, freedom of speech versus right to religion, sometimes you will notice that right to religion will have to be subservient to freedom of speech. So that conflict is also something that rule of law may attempt to regulate upon. Because, see, when we say rule of law, it is also about the interpretation of law sometimes. It is about the interpretation of fundamental rights, and that is also very core and important. Also, please understand that fundamental rights can be positive, they can be negative. So some of them can actually give you some kind of a negative right, as the case may be, and some may give you very positive right. And please note, these kinds of fundamental rights are supposed to be available against state, most, right? However, you cannot say that it is only against the state or the government. It can be against private individuals and private actions as well. So, who is supposed to protect these rights and who is supposed to be held accountable for the violation of this right? Please note, it is not limited only to the state. It can be also available against private companies, private individuals as well. Of course, you will notice that these fundamental rights can be suspended. You have to agree to this. And this has been a part of a major constitutional debate and change, that can fundamental rights exist during a national emergency. Now, you will notice that except Article 20 and 21, your fundamental rights can be suspended, right? Please note, except Article 20 and 21, your fundamental rights can be suspended during a national emergency. Uh, so, you know, understanding fundamental rights and national emergency, you will notice that sometimes national emergency is given prominence, and fundamental rights may not be given that kind of a prominence. However, 20 and 21 are very, very important, because 21 speaks about right to life and 20 speaks about your rights in case you are arrested, and what happens in case you are arrested is what is mentioned over there. Now, please also note that Article 19, which is about your six freedoms, can only be suspended if the emergency is declared on war. So it's not general national emergency. If there is war or external aggression, which results in a national emergency, then even Article 19 can be suspended. It's not automatic, it has to be suspended by the government. And that is something that one will also have to take consideration of. Um, Also, what's very interesting under fundamental rights chapter is how you can actually deal with some of these violations of fundamental rights. You can actually approach to the constitutional courts under Article 32, which is also a fundamental right in itself. So going to the court for the infringement of any of the other rights is also a fundamental right under the constitution. So that creates a very interesting concept under the Constitution of India. Um, yeah, are fundamental rights the basic structure of the constitution? That's a big question. Can it be changed? Of course it has been. And you will notice that we had a fundamental right to property that now is taken off, and hence there have been changes to fundamental rights. For example, we have added a new fundamental right called right to elementary education. So I'm sure fundamental rights are part of basic structure, and some kind of progressive change in fundamental rights can definitely happen, and that is something that the judiciary can always evaluate and see. Uh, that's what can be the basis of the discussion here. So moving further, friends, I think in the protection of fundamental rights, the judiciary plays a very, very critical role. And I think the judiciary is the institution that is expected to do justice. It is expected to settle disputes. It is expected to pronounce the law of the land. It is expected to also lay down the public policy. It is expected to state the limits of public administration. It is expected to compensate for the infringement of rights. It is expected to actually govern the limitation of the other two organs of the government. Under the doctrine of separation of power, no strict separation anyhow is followed. But the judiciary is expected to regulate the legislature and the executive in case they actually enter into some kind of unconstitutional act. So I think an independent judiciary is core to the protection of fundamental rights. And I think in India, like no other country, I think we have realized the importance of the judiciary and its role in upholding rule of law, in upholding the fundamental rights, in laying down the foundational principles of democratic process. Even if you are being infringed of your life or liberty, it can only happen through the democratic process and not through anything else. So I think a strong judiciary would bring in the predominant spirit of law and rule of law in this country. And I think India has experienced that quite well in the way and manner in which fundamental rights have been interpreted. Just as as a preliminary example, one would look at Article 21 and how the judiciary has looked at just the definition of life under Article 21. You will notice that it has played a very, very important and significant role in looking at arbitrary actions of the state, establishing the supremacy of the constitution and protecting fundamental rights. So you need a guardian angel for protection of fundamental rights. And in most countries, especially in countries like India, I think the guardian angel for the protection of fundamental rights or protection of any kind of human right happens to be the judiciary. A stronger judiciary means a stronger element of protection of rights. A stronger judiciary means a stronger element of protection of democratic principles. And that is quite very important as well.